This Honorable Court of Appeals is now in session.
Good afternoon, everyone. Judge Stafford and Judge Armstrong and I welcome you to the Court of Appeals. If we should have any technical difficulties during this, which we did this morning, we will take a pause and see what we can work out, okay? But we don't anticipate any problems. Ms. Lindsay, would you please call the case?
In re Conservatorship of Ruth Tomlinson Osborn.
Okay, is the appellant ready?
Yes, sir.
Okay, anytime you're ready, you can begin.
All right. Your Honor, I do not see Mr. Rader anymore, opposing counsel.
I'm here.
Okay, he's there. He's just, I didn't see his picture. I apologize.
That's okay. Thanks for asking.
All right, Your Honor, this is the case that started out when a lady by the name of Miss Ruth Tomlinson.
Miss Patterson, we know who you are, but you need, since we're recording this, you need to introduce yourself. So we've got a record
Okay, I
of that.
apologize. I'm Linda Patterson. I'm a member of the Overton County Bar in Livingston, Tennessee. That's where my office is. I've been in practice of law since 1990. I represent Mr. Harlan Dixon and his wife, Miss Grace Dixon. Miss Grace Dixon is the daughter-in-law, or excuse me, the daughter of Miss Ruth Tomlinson Osborn, or Miss Ruth Osborn Tomlinson. And Mr. Harlan Dixon is her son-in-law. They've been married, Mr. Dixon, or Mr. Harlan Dixon and his wife, Grace Dixon, been married several years. They live in Cookeville, Tennessee. And in fact, they are the only family members that live close to where Miss Ruth Osborn Tomlinson lived. This case started back in February of 2015 when it was discovered by Adult Protective Services that Miss Ruth Tomlinson was in need of their services. So a petition was filed before the Chancery Court of Putnam County and seeking to bring in Adult Protective Services as being on board as her caregiver or making decisions for her. That later, in May of 2015, Miss Kelly Tays was appointed to be her conservator. Initially, Miss Tomlinson was placed in a nursing home, and later on, she was transferred and lived in a home where there were other people that Miss Tays was caring for living, and they shared rental expenses and things like that. An independent living of some sort. So over the court, in later on, what happened was there was a separate case filed by the conservator to set aside some conveyances of property that Miss Osborn had done prior to her becoming incompetent. She had made different transfers of real estate. She was a doctor, so she had accumulated some assets. Those properties have been transferred to Mr. Harlan Dixon, her son-in-law, and Miss Grace Dixon, her daughter. Miss Kelly Tays sought to set these aside so they could be sold to provide for her care. Ultimately, this case, well, let me back up a second. Chancellor Thurman recused himself because many different attorneys, including myself, had prepared deeds in this case back through the years for Miss Osborn. So he recused himself, and this was sent to another chancellor. Ultimately, the case was settled, and the chancellor was Mr. David Pemberton. Ultimately, this case was settled in 2018. And the only issue before this court was the settlement that was made in reference to a piece of property located at Fox Knob Lane in Cookeville, Tennessee, Putnam County. And this property had been owned or was transferred by Miss Osborn to Mr. Harlan Dixon and Grace Dixon. And it was a joint tenancy with a right of survivorship. So this property was settled in the settlement agreement, and specifically stated, and this was important, we feel, that it was to remain as a tenancy, joint tenancy with a right of survivorship. But however, if Dr. Osborn needs medical care and there's no other viable option to pay for said care other than selling this property, the parties agree they'll cooperate to sell said property. She'll list it and she'll agree to reasonable sales. This agreement came in the latter part of, or the early part of 2018. By the latter part of 2018, Mr. Rader, who represented Miss Kelly Tays, filed a motion back into the, well, prior to that, there was a proceeding in the conservatorship to approve this settlement agreement. But the settlement agreement that was ultimately produced into an order provided that if there were any other issues or disputes, that those would be resolved in a hearing that would have been set for January 25th. Now, I don't think they went to any type of hearing. It was just the settlement agreement. But it left the case open as our position that if any issues needed to be resolved concerning the settlement agreement, then that would go back to the court in case the case that Judge Pemberton heard, case number 21577. What happened was that ultimately, in late 2018, Mr. Rader filed a petition for the Chancery Court in the conservatorship case to sever the property interest of Miss Osborn and be allowed to sell that tenancy to pay some debts. Ultimately, the chancellor ruled in favor of that, and the appeal proceeded from this. By the time the appeal was filed, actually in November of 2019, Miss Osborn passes away. The court can see from the records that all the bills were paid, and really what is left in this situation that we have is debt owed to Miss Kelly Tays, who was the conservator. About $90,000, a little over $90,000 was approved by the court that was still owed to her. Other than that, the last accounting says that the balance was zero, but it did leave possibly Mr. Rader and Miss Kelly Tays not being paid. Over a span of 4 years, Miss Osborn's estate was totally depleted. And at the time they filed this motion, there was still money that was still available to Miss Osborn's conservator to use for her care. And it was discussed that ultimately, if she ran out, had she lived, that she would have had to gone back into a nursing home. It's our position that Miss Osborn did planning, like a lot of people do, not wanting to lose everything that she had for her family prior to if she became incompetent at some point or became to where she needed full-time care at some point in time. But that's exactly what's happened in this case. So it is our position that, first of all, the issues in this case is that Mr. Dixon and Miss Grace Dixon were never made parties to the conservatorship proceeding, and that selling this property because of the nature of the property would be affecting their interest in this property. And furthermore, that because this was done in a separate proceeding to which Chancellor Thurman recused himself on his own motion, and because the order said that it reserved future issues to be heard by Judge Pemberton, that this should have been filed in Judge Pemberton's court. He was the one who approved the settlement agreement, and that's where any issues of interpreting the settlement agreement or determining what needed to be done should have been done in Judge Pemberton's court. And furthermore, they did not serve Mr. Dixon or Miss Grace Dixon, but filed it simply as a motion, and it's our position that he was not brought into the jurisdiction of the court of the conservatorship. And finally, that Judge Thurman, if he had a conflict, remained a conflict, and he should have sent it back to Judge Pemberton.
Ms. Patterson, you argued that the other judge signed the settlement agreement that's in question, but that isn't accurate, is it? Is it? Didn't Judge Thurman sign the settlement agreement that affects the property involved here?
He approved it in the conservatorship. Yes, that is correct.
Okay.
I'm sorry about that. I apologize.
Okay. And of course, you never filed a motion for him to recuse himself, did you? I
didn't, but by the time I came in it, that had been argued by Mr. Henry Fincher, who had previously represented Mr. Dixon at the outset of the hearing, which was held in June of 2019.
And the issues involved in that other case had nothing, which involved, various attorneys would be witnesses. In this case, involving the settlement agreement, there would not be any attorneys who had practiced before him or he had relationships with in making a determination about whether the facts were such that interest held by your clients should be ended.
That would be correct. It would no longer be an issue of the deed. It's our position. It would be the interpretation of the order and whether or not the terms of that order required the sale or didn't require the sale at that moment in time would have been the decision of the court where the case was filed.
Okay.
You say Mr. Fincher raised the issue of recusal?
Yeah, yes, he did, and he raised the issue of jurisdiction.
In this case, the case that's on appeal now?
Yes.
Is that in the record?
Yes, sir.
Okay, and I'm assuming that the chancellor denied the recusal motion and set out his reasoning for denying it.
Yes, it was discussed and argued by Mr. Rader and Mr. Fincher that that no longer was their attorneys involved.
Okay, and the chancellor put down an order, I'm assuming, setting that out.
Well, I don't think the order clearly sets that out. I don't think it sets it out at all. The order from the 2019 here, it was June of 2019 when they had that hearing.
Okay, well, we'll let Mr. Rader address that one during his. Thank you.
Mr. Rader, it's your turn.
Thank you, Judge. May it please the court, my name is Danny Rader, and I do represent the conservator in this case. I'm pleased to be before the court today and look forward to getting back in front of you all in person at some point in our lives. To address Judge Stafford's question and Judge Armstrong's question about the recusal, Ms. Patterson wasn't there, so she may not recall this accurately. In the June 2019 hearing, there was no request at any time for Chancellor Thurman to recuse himself. There was never a request throughout this conservatorship case for Chancellor Thurman to recuse himself from this conservatorship case. It was mentioned by Mr. Fincher at the June 2019 hearing that Chancellor Thurman had recused himself from the related case just as part of the preliminary comments. Chancellor, let me refresh your memory as to why we're here today, what the background of this is. We settled this case. You were not involved, although it was a Chancery Court case. You recused yourself from that case. And so that discussion was had, but there was no request by Mr. Fincher or anyone else for Chancellor Thurman to recuse himself from this case. Certainly no written motion was filed as required by Rule 10, and no order reflected a request for recusal because none was ever made. So I hope that answers that question. Ms. Patterson wasn't there and may not have recalled that.
Yes.
With respect to the issue that we are here before the court today, I think it's important to note that the appellant has not appealed Chancellor Thurman's findings after an evidentiary hearing that the severance of the joint tenants was in Dr. Tomlinson's best interest, in the ward's best interest. And he made that finding after a lengthy evidentiary hearing in which the appellant Harlan Dixon testified. And of course, they have not appealed that decision because Mr. Dixon agreed and admitted during that hearing that it would be in Ms. Tomlinson's best interest to be able to remain in this independent living arrangement in this home. And of course, the only way that that could occur is if this property, the Fox Knob property, was there to answer for those costs. And those costs, as was testified to in the evidentiary hearing, and as the chancellor found in his findings, his detailed findings of fact and conclusions of law, the only way that that was able to be done was because the care was being furnished on credit. And of course, Ms. Patterson argued that the only debt that's owed is a debt to the conservator. None of that is in the record, and respectfully, it's not correct that the claims are filed in the probate court against Ms. Tomlinson's estate. They include a claim by Bethesda, a nursing home, where Ms. Tomlinson stayed for a period of time before returning to the independent living facility. That debt was forestalled all through the last years of her life because the Fox Knob property had not been available to answer for it. There is debt owed to the home caregiver service, and there is some debt owed to the conservator for her services, and the court approved that fee, but none of that's in the record before the court. The faulty premise that the appellant has here is that Mr. Dixon and Miss Dixon had some interest in Miss Tomlinson's 1/2 undivided interest in the Fox Knob property, or the joint tenancy with right of survivorship. That has been foreclosed by the Bryant case from the Tennessee Supreme Court in 2017, where Justice Kirby made crystal clear that when you have two joint tenants, even with a right of survivorship, their interests are separate and they're distinct. And either joint tenant may, and the case says without knowledge or consent of the other party, may sever that joint tenancy and may terminate that right of survivorship. That property interest does not belong to the other joint tenant. They don't even have any right to know about it or consent to it or participate in it. And that's the faulty premise here, that Mr. Dixon claims that he should have been brought before the court or some other mechanism pursuant to the Bryant case in the Tennessee Supreme Court's direction. He didn't even have any right to know about it. However, in a conservatorship, we try to give notice to everyone of what's going on, let them come have their day in court, let them have their opportunity to be heard. And Mr. Dixon did come, and he did participate. He did testify. He did oppose it. The chancellor ruled that it was in Ms. Tomlinson's best interest, Dr. Tomlinson's best interest, to sever that joint tenancy. And that was done, and a deed was prepared based on the chancellor's ruling to sever that interest. And so that did occur. With respect to whether or not they were properly before the court, that's really the only issue that has been raised in this appeal by the appellant that was even touched upon in court. And they didn't phrase it in that way. Their appellate issue is whether or not the court deprived them of due process. And of course, that phrase does not appear anywhere in the record because it was never uttered at any time before this appellate brief. But whether or not they're properly before the court, I think is somehow tangentially related to that concept. And so I would like to address it. Number one, Mr. Dixon made not one, but 3 general notices of appearance in the conservatorship case. They're in the record at pages 35, 158, and 317. Those general notices of appearance do not reserve any right or assertion. And of course, Mr. Dixon did that before he knew that severing that Fox Knob property would become an issue in the case. He first did it when he wanted to participate in who was going to be appointed the conservator. My client was appointed upon the motion of the state DHS. And so Mr. Dixon and Mrs. Dixon participated in that. They participated in the accountings. They participated in the motion to approve the settlement agreement that Judge Armstrong talked about. Chancellor Thurman was asked to approve that settlement agreement as to whether or not it was in the best interest of the ward, Dr. Tomlinson. Mr. Dixon and Ms. Dixon and their attorney participated in that motion, signed the order approving it. Of course, they wanted it to be approved. They wanted the court to approve that settlement because it allowed them to keep some other properties that are not part of this case now. They only had to return a few of the properties that had been deeded to them, which is, the nature of a compromise settlement. But they wanted the court's approval and they wanted to participate at that point. Then only later, and really only on the morning of the hearing, did their attorney say something about, well, they've not been served and they're not properly before the court after having made those multiple general notices of appearance and participated in the court. And the case law I cited in my brief talks about when you make a general notice of appearance, when you come to the court and you ask for relief, when you participate in the request for relief, when you obtain relief from the court, as Mr. and Mrs. Dixon did in the context of the settlement agreement, and you act inconsistently with the idea that you're not properly before the court, you can't make that claim. And so that's the only claim that has even colorably been raised on appeal that was addressed in the trial court. The chancellor correctly ruled and addressed that argument head on, looked at the record and said, no, you're before the court. You've made these appearances. There's an order down addressing this. I think that he was referring to the settlement agreement that he approved at their request and at my client's request. And so he determined they were properly before the court and proceeded. Again, whether they were properly before the court or not, respectfully, isn't even relevant because their participation wasn't required. Their knowledge or their consent was not required for the chancellor to sever that joint tenancy interest because the Bryant case says that they don't have any right to Ms. Tomlinson's 1/2 undivided interest or her plan. The case law says that if a conservator is going to alter a conservatee's expectancy interest as far as a future distribution of her property, they have to bring that before the court, and it's the court, not the conservator, that gets to make that decision as to whether or not that's in the ward's best interest. That's exactly what the conservator did here. She brought it to the court's attention, said, if you leave this right of survivorship and Mr. and Mrs. Dixon run out the clock so that they can take this property in whole, and the asset is not available to pay these debts, then Ms. Tomlinson is not going to be able to remain in this home. The caregivers are not going to furnish this benefit on credit, and she's going to have to go into the nursing home. As Your Honor may recall from the brief, she was not eligible for TennCare, and that testimony came up repeatedly during the evidentiary hearing because of those conveyances to Mr. Dixon within the 5-year look-back period. So it had depleted Ms. Tomlinson's assets. There was no other way to give her that quality of life but for this asset to exist available to her estate to pay those debts upon her eventual passing. That's what the chancellor found to be in her best interest. Mr. Dixon testified it was in her best interest, and that's what did happen. We think that that's proper in all respects. We don't think there's any ground for it. None of these other issues, due process, recusal, were raised in the trial court at all. We submit that they are waived and that they're not properly addressed to the court today. We would submit to the court that respectfully, this has been going on for a number of years, and the attorney's fees involved with trying to resolve this issue concerning the Fox Knob property continue to accrue, as your honors understand. And I don't ask for a frivolous appeal very often. I can only think of one other time that I have asked for it in my entire career. But this is a case where we're asking the court to award fees for a frivolous appeal because this appeal respectfully did not have any chance of success, particularly since the issues being raised were not issues that were raised in the trial court. And because the Supreme Court's holding in Bryant, a reported case from 2017, clearly forecloses the argument that Mr. or Mrs. Dixon had any right to control Dr. Tomlinson's severance of the survivorship issue. And this case did not have any legitimate need for an appeal to incur those additional costs. All the money that gets spent on attorney's fees in this case, of course, if the court somehow awards Mr. Tomlinson the entire property at Fox Knob and somehow sets aside the chancellor's survivorship interest, and there's no money to pay any attorney's fees or any of the debts owed by Ms. Tomlinson to her caregivers or to the nursing home or to the conservator or to pay my fees. But if the court does allow this to stand, which I think respectfully it should, the chancellor's ruling is proper in all respects, then the attorney's fees incurred in this appeal are going to eat into what's left of that Fox Knob property and prevent the creditors from getting their portion and any leftover money to go to the 3 daughters. Miss Grace Dixon is one daughter of Miss Tomlinson. There are 2 others, at least one of whom participated in the trial another one had health problems and was not able to participate. But those are the beneficiaries of Ms. Tomlinson, not just Grace Dixon. And so any money that's left over should go to all three of those daughters. And it's being eaten up by these respectfully unnecessary attorney's fees. And so I'd ask the court in its discretion to award damages for frivolous appeal. I know the court does it from time to time. I know you all are reluctant to do it, as I would be if I were a judge, but this is a proper case for that. And I respectfully submit that the court should do that. I'm happy to answer any questions that the court may have, but I believe I've covered all the topics that are raised.
I see no questions, so thank you, Mr. Ryder.
Thank you, Judge Bennett.
Ms. Patterson, you have
Yes,
5 minutes.
Okay. This case is a little unique is because the way the settlement agreement was structured, providing that they would have had to have filed a motion, petition, or something to come back before the court to sell the property. So it wouldn't have been just, as Mr. Rader said, that the conservator could have sold the property without giving anybody notice, because by the very nature of the language of the settlement agreement, it said it had to be shown that there was a need for this money, for this property to be sold for her medical care, and there was no other viable option. So that necessitated bringing this back before the court. Prior to Mrs. Dixon and Mr. Dixon was, I'm sorry, let me back up just a second. So this is not frivolous, Your Honor, in the fact that even the Chancellor Thurman, in the last transcript of the last hearing that was appealed, that the appeal came after that last hearing, wasn't, and even made a comment, I might be wrong, but about whether or not this court has jurisdiction, but that can be taken up by the Court of Appeals. Mr. Dixon and Mrs. Dixon, although they had an attorney, never participated in the actual conservatorship proceedings prior to the hearing at which in 2019, in which the issue was whether or not to sever this property. And prior to the beginning,
Wait a minute. Didn't they execute a settlement agreement that was presented to the court and approved?
yes, I apologize. That was a settlement agreement from the other case. That agreement was approved by the court in the conservatorship. And then there was a hearing on whether or not later on, several months later, whether or not they should sever the property under this agreement. It's our position the court would have needed to approve, or this should have been filed into the conservatorship case, because that was where the issue of Miss Tomlinson's conservatorship was. So it would be a natural thing to file and have the conservatorship judge approve this case. But the real argument came from the motion that was filed asking to sever. And this agreement was made in a separate case, and the terms of that agreement should have been interpreted or ruled upon in that separate case. And that's just simply what was not done in this case.
So I'm having a little difficulty here understanding your argument. Are you saying that another judge should have heard this?
I think that it's our position, the judge who this case was filed in, the case number being 2015 CV 77, which was a separate action from the conservatorship. And that was the action to set aside these properties that were conveyed to Mr. Harlan Dixon and Miss Grace Dixon, the daughter of Miss Tomlinson.
But don't different judges hear different things in different cases all the time?
I'm sorry, what? I apologize.
I have difficulty with the belief that a specific judge needs to hear a specific case, because different judges within a circuit or different judges who are designated to hear things, hear all kinds of cases at all periods of time. Just because some judge has participated in a case doesn't mean that's his case or her case forever, does it?
No, not necessarily. That's correct. But we go back once again to the fact that Mr. and Miss Dixon, they had not, other than when the settlement agreement was entered with the court, they didn't participate in these proceedings, even though in the conservatorship proceedings, even though Mr. Fincher represented them, they didn't testify, object to the conservator. They were there as interested family members of Miss Tomlinson. The proceeding in which they participated in and which they were made parties to was case 2015 CV 77.
One question.
My
Ms.
time's up. I'm
Patterson.
sorry.
Were there two separate settlement agreements? One that was filed in that separate lawsuit that was filed in Chancery Court, and then another settlement agreement that was filed in the conservatorship action?
No, they were all the same settlement agreement.
Okay. But
But
involved,
it arose out of case 77.
okay.
Okay, I see no other questions. Thank you very much, both of you.
Thank you.
Ms. Lindsay, would you recess court?
This Honorable Court of Appeals is in recess until 2 p.m.
Thank you.
Thank you. You all can check out now.
All right. Thank you.
Thank you.